We're here to assist the court on matter.
Mr. Liu, come forward.
Can I enter the warrant and place this proceeding on my full resolution, all my rights?
Mr. Liu, you can come forward. So this comes before the court on a motion to proceed pro se. The court notes that this motion was denied previously by the court on June 18. And when it was denied on June 18, the court indicated that if it were to be brought again, it would need to be brought on this calendar as what I would characterize as a gatekeeping function, just rather than have another evidentiary hearing absent renoting the motion here. The reason for that is that there was nothing different, then the court will set it on the full evidentiary hearing. Mr. Swaby, good morning to you.
Good morning, Your Honor.
Your Honor.
Mr. Liu, this is your motion.
Your Honor, who is Mr. Sweeney representing?
He's the assigned attorney for the defendant.
For the defendant? The defendant candidate, Your Honor?
Are you the defendant?
No, I'm not the defendant, Your Honor.
Do you have any different responses to the questions that we went through on June 18th regarding your request to represent yourself?
Yes. What question was that?
When I was last here in the court, Your Honor,
Excuse me, Judge, Your Honor.
sorry, Judge.
You can address all the questions to me and you can just stand by.
At this point, Mr. Liu, he is your attorney. The court has appointed him to be your attorney. And he's your attorney.
Who's the attorney?
Identity is clearly an issue here in this case for the person who is named as a defendant. And the person who is named as a defendant surely does not want to give up any rights to any claims he has made as a defense under the UCC, Uniform Commercial Code, Your Honor. So I know that person is concerned about advancing arguments through counsel when this person argues that he should be able to represent himself. I think when we were last here, the court's major concern was, major is my characterization, I don't know if that was the court's major concern, was that the person who is named in the information, that Ken Liu, who is being charged with these crimes, if that person knew that that person would be incarcerated as a result of a conviction after a trial. It's my understanding that that person understands that the person named as a defendant, the court believes, could be incarcerated as a result of those facts. I'm going to say again, Your Honor, that the person standing next to me, with whom I've spoken, in my experience with the law, is competent to proceed pro se. He understands that he will be held to the same standards as an attorney. He has availed himself of the rules of evidence. He's obviously been able to file motions. He would like very much to represent himself, as at least one of his co-defendants. He believes he has the right to defend himself, and I believe that he believes that having a lawyer represent him is in conflict with his rights under his rights of personal. So,
Mr. Swaby, you have now spoken. Mr. Liu, what do you want to say?
Your Honor, who is the public defender representing?
This is your motion. I'm hearing from you.
Okay. I have something to say in the record. I am experienced living man of flesh and blood, therefore administrator, authorized representative, and a paramount security interest holder for all sweat equity of Liu Ken Liu. I am a living spirit man on God, cannot be reviled life, liberty, and property, and pursue happiness without due process of law. I do not consent to being surety or guarantor for cause number 18-1-00444-34. I have signed and filed the 1889 State of Washington Constitution to the court that makes I am part of the contract. I understand that the 1889 State Constitution prevails over statute and codes like RCW, Revised Code of Washington. I understand Washington State is a New Jersey and State of Washington and County of Thurston and a corporation for profit. I understand County of Thurston Superior Court enforce statute codes and not a court of law. Judge who is dealing with a statute and code like Revised Code of Washington become a clerk working for an agency, which is stated in K.C. Davis Admin Law, Chapter 1. States, judge who become involved in enforcement of murder statute, civil or criminal in nature, and otherwise act as a murder clerk of the involved agency. I, Lam Liu, understand that Liu Can Liu is a corporation created and owned by the United States Inc. to be used for collateral for public debt, remedy for man, birth certificate, United States citizenship certificate, a bond, financial instrument, document ready for use to set off settlement closure for violation of the statute and codes. I am the authorized representative of Liu Can and hold no liability based on the definition of authorized representative UCC 3-402. Referred to I Lam as a defendant, Liu Can is a direct insult to I Lam's culture, religion, and belief will be tolerated as an act of war. I Lam understand defendant Liu Can is protected by the U.S.C. Title 18, Section 4001, which states, no citizen shall be imprisoned or otherwise detained by the United States of America except pursuant to an act of Congress. I Lam understand that the public attorney as an officer of the court and based on the corporate searches, Citrum 107, Section 4, attorney-in-client state, his first duty is to the court and the public, not to the client. And whenever the duty to his client conflict with those who he owes as officer of the court is the administration of justice. The former must yield to the latter. Therefore, I am grantor, administrator, and authorized representative of Liu Can will not place I liberty in hand of any officer of the court, for this court is not a court of common law, or a common man of common knowledge.
So, Mr. Liu, I have listened carefully to what you have said, and even characterized you. If the court were to suggest you're the defendant's insulting to you, I don't mean to insult you. I have listened carefully, though I hear nothing different from the court's concern on July 18th. On July 18th, the court denied your request to represent yourself, not because, as your counsel said, capacity. I don't believe that you do not have the intellectual capacity. I'm speaking. You don't have the intellectual capacity, but the court is concerned is under the case law, you don't have a general understanding of the consequences of representing yourself. And for that reason, I'm denying your request.
Your Honor, why you can refer me to this division?
Would the court like an order to the same?
Yes, and the court's concerned that there did not appear to be a written order from July 18th.
June 18th, Your Honor?
June 18th, I think.
We prepared one, Your Honor, so I'm not sure. I mean, I vividly remember handwriting it out, so.
It is June 18th. I didn't say July. I was mistakenly said July. Mr. Swain, I'm sorry.
I'll prepare. Would the court like me to prepare two? One for the June 18th?
No, just reference both decisions.
Yes, Your Honor.